And you'll have to scoot way in. Oh, okay. This is going to be a multi-voice, test number 1 at 180 words a minute. Proper names are State, Court 3, Mr. Factor, Demurrer, Roman, Officer Sandoval, Rule, Sandoval, and Tice. And I'm going to be Mr. Berger.
I am Mr. Factor,
The court.
And this is all colloquy.
Have we got our motion to suppress paper here?
The state is ready. I believe we're awaiting the clerk's file.
I think I've got it right here. This is from court 3.
That's right, Your Honor.
All right. Defendant's motion to suppress evidence obtained by unlawful search and seizure. Mr. Factor,
Yes, Your Honor.
are you ready to go?
Yes, Your Honor.
Will you and your client take your place at the counsel table, please? Now, let me see. You all sit down. Let me see if it's not too long. Let me read it. It would help if I reread it. Now I, having read this again, I recall my initial impression. Sounds like to me like you have, in effect, filed a general demurrer to state's case, saying that they may have seized some illegal evidence, and they may be planning to count on that illegal evidence. And unless they show that that's not so, that you want me to suppress all their evidence and thereby run them out of court. You haven't specifically set forth anything yet that you want to suppress except possibly items seized from a search of vehicle, which may or may not have been done for inventory purposes. What else are you seeking to suppress?
Your Honor, anything seized or taken from a person which was a result of the same detention and arrest.
We're back to sort of a general demurrer then. You don't know of anything that was seized that you want to suppress introduction of or anything of that sort? You just want a general order from me suppressing any evidence that they may have seized?
Your Honor, I think the only evidence seized in this case or taken from her as a result of this detention is in fact what forms the basis of the allegation in the case, because obviously anything seized from her that is not contraband or prohibited would not be relevant for evidentiary purposes.
Well, I am sure that that's true, but I'm glad that you pointing out the fact that you were complaining that they may have seized something that they would not particularly characterize as marijuana.
Yes, Your Honor.
You want to suppress that.
Yes, Your Honor.
All right, very well. Can you think of anything else in connection with the proceedings that you feel was improper, such that I ought to be paying particular attention to it, other than the fact that some green leafy substance was seized?
Not for the purposes of this hearing, Your Honor. I think our motion, and I think we're generally here for the purpose of determining the legality of the search and whether the items taken from her should be admissible in evidence.
Thank you very much. Before we proceed, Mr. Berger, do you have any comments or requests?
Not really, Your Honor, other than paragraph 3 of defendant's motion, which talks about the seizure of these items were illegal and that the search was not confined to the defendant and goes on along those lines.
You mean Roman 3? Because I'm looking up here. Paragraph 3 says statements or admission made by the defendant at the time of her arrest.
Yes, Roman numeral 3. And again, my understanding is that the items seized were specifically from the person of the defendant, and anything else that may have been confiscated is not really within the scope of this particular case. There might have been other contraband that may form the basis of other cases, but this particular case would be confined to the marijuana seized from the defendant's person. So defendant's motion seems to go outside the scope of this case, but other than that, I don't have any problem.
Well, if you didn't seize anything that you could conceivably use in this case during the search of the automobile, then you don't really have a problem there.
No, I don't.
Because if I were to grant a motion to suppress anything seized from the automobile, it wouldn't hinder you if you didn't seize it.
Right.
Now, that means that we've narrowed it down to apparently you're claiming that there was on her person some marijuana.
That's correct.
At the time of her arrest.
That's right.
That it was in due course seized by officers of the law and that they now have it in their custody, ready to show it to this or our sister court on proper demand.
Right.
Now then, how about you putting on one or more witnesses to show how that marijuana came into your possession. I'm referring to your side of the lawsuit as opposed to their side of the lawsuit. Perhaps I can then rule on their motion.
Very well. We have 2 witnesses standing by, and the state will call Officer Sandoval.
Would you bring both of them in and let me swear them in? Do you care for the rule, counsel?
Yes.
What are their names?
Sandoval, Sandoval, and Tice, Tice.
And the arresting officer or sponsoring officer witness is Sandoval?
That's correct.
And Tice is another officer or
Your Honor, I believe the evidence will,
what?
he's the supporting officer.
He's what?
He's the backup officer, but he's the one that actually found the marijuana. But the offense report, as I understand it, was completed by Officer. All right, this is going to be your multi-voice test number 2 at 180. Proper names are Sharon, Robert Forsberg, Mr. Pena, Exhibit 8, R&R Motor and Transmission, and I'm Mr. Robert.
The witness?
Mr. Curl.
I'm Mr. Robert.
The witness?
Mr. Curl.
We start with the questioning by Mr. Robert. Was she satisfied then?
Not really. Just felt that she shouldn't have had to have brought it back.
Do you recall anything else that was said?
Not unless you can refresh my memory, no.
Any other conversations that we haven't already talked about between you and Sharon, or even you and the unidentified fellow that came with her?
At any time?
Other than what we have already discussed.
Not that I can recall.
You're familiar with Robert Forsberg?
Yes, sir.
Are you familiar with the estimate he did on this vehicle recently? I say recently, last year.
Yes, sir.
I will hand you what will be marked as 8 and ask you if that is that estimate.
Yes, it is.
Do you agree with any of Mr. Forsberg's conclusions?
Yes, sir, I do.
Which? I would like to talk about each of them about why.
Before we do you want to get them in order?
Mr. Pena, we are getting ready to talk about Mr. Forsberg estimate. You indicated you had some things about it that you disagreed with.
Yes, sir.
It's important for us to know in detail what you think is wrong with what Mr. Forsberg has said in his estimate, Exhibit 8. Let's take it item by item. If you disagree with something, we don't need to talk about it. To the extent you disagree, let's talk about each of them. Let's start at the top.
Front bumper brackets, 8 hours to repair.
What's wrong with that?
There is no damage to the front bumper brackets.
That's because you replaced them?
That's because I looked at them.
So there shouldn't be anything with respect to the front bumper brackets. Is that your testimony?
Yes, sir.
Next, do you have any problem with the...
Replace the front frame cross member needs to be replaced at this point. I disagree with the monetary value he put on the cross member.
Why do you disagree with the value of the part?
I'd like to know where he got his parts prices.
What do you think was appropriate for it?
I've used today's market, today's manuals available for pricing such items.
Do you know what that price is?
I could find it, look it up.
You don't know off the top of your head whether it's $410?
Not off the top of my head, no. I wouldn't put anything off the top of my head.
You know that is too high?
I know that is too high. Yes, sir.
The next item?
Repair front of frame other. I disagree with his terminology. His front frame or repair front frame other, and at $600 to be specific as to what other he's talking about. Where is the damage? What damage is he talking about?
Is that your testimony that there is not $600 worth of repair that needs to be done in the front part of the frame, or you just don't know?
I will object to you cross-examining him about these things because, number one, he hasn't been able to see the car. You were asking him about his estimate, is what you started doing. Now you are cross-examining him about the necessity for these things when he has not had the opportunity to see this car.
I asked Mr. Pena if he had any disagreements with Mr. Forsberg's estimate. I think it is important, if he does disagree, what the basis of his disagreement is. If he hasn't seen the car, he doesn't have a basis for disagreement. We shouldn't be talking about this.
He can still disagree. I'm saying you can't ask him if there is any damage to the front end when he hasn't seen the car. How can anybody answer that if he hasn't seen it?
If he disagrees, I'm entitled to ask him why, and that is all I am doing.
All right. I will tell you that you don't have to answer a question if you don't have sufficient information. You can still disagree with this estimate based on what you do.
Yes, sir.
Go ahead. Tell him why you disagree with that.
I believe that the estimate ought to be written specifically. Repair frame, upper right corner, lower right corner, upper right side, lower right side, and then supposedly sees this damage.
You don't know from this or from your own knowledge whether or not the total of those items might be $600?
I would say it is impossible that the car had $600 damage on it.
Impossible?
Yes, sir. At this point, having repaired the car, unless it has been in another accident, it could have more damage than that now. When it left my shop, it didn't have $600 frame damage on it.
That you could see. Next time, clean up front, looks like bumper.
Clean up front bumper. We put a re-chromed bumper on the car, charging $75 to clean it up.
You say that shouldn't be there?
That shouldn't be on there.
There's nothing wrong with the front bumper?
Not unless she has hit something. I don't know.
R&R motor and transmission. What does that mean?
Removal and reinstall the motor and transmission for $375.
Anything that you disagree with there?
Other than the cost,
All right, this is going to be multi-voice test number 1 at 160 words a minute. Proper names: Anita Brown, Nita Brown, Harris, Birmingham, Alabama, Birmingham, R.E. Brown, LNZ, CDL, Pat Patterson, Pat, deposition exhibit number 9, exhibit 11, and Pat Peters. I'm going to be Mr. Hardy.
the witness,
Mr. Schuyler.
Mr. Hardy.
the witness,
Mr. Schuyler.
And we're going to start with examination by Mr. Hardy. Please state your full name for the record.
Anita Brown.
And most folks call you Nita, is that right?
Yes.
And am I going to offend you today if I call you Nita?
No.
All right. Have you ever been known by any other names?
No.
Is Brown your married name?
Yes.
Well, what was your maiden name?
Harris.
How do you spell that?
Harris.
Nita, have you ever given your deposition before?
Yes, sir.
How many times do you think you've given your deposition?
This deposition?
Any deposition with a court reporter, not just this one.
Just one.
Just one time.
Yes.
Okay.
Let me just tell you something to make this go better. Wait until he's completely done talking before you start talking. Just make it easier on the court reporter, okay?
Okay.
Thank you.
It's hard for him to get two people talking at the same time, but you're doing fine. Also, I need you to answer out loud because it's tough for him to get shakes of the head and things like that, okay?
Okay.
All right. Tell me about that first deposition that you've given before. When was that?
It was in December of 2002, I believe.
Okay. And do you remember where that deposition occurred?
In Birmingham, Alabama.
And do you remember where that claim originated out of?
The accident occurred in Birmingham.
Okay. And do you remember basically what the case was about?
It involved a truck and a car.
And do you remember the name of the truck driver?
Tim. I can't remember his last name, but his first name was Tim.
Was it Smith? Does that sound familiar?
Yes, I think so. That sounds right.
Do you remember the name of the attorney that was representing R.E. Brown?
Well, it wasn't with Brown. It was LNZ.
It was LNZ?
Yes, sir.
Do you remember the name of the attorney that was representing LNZ?
No.
Do you remember the name of the plaintiff's attorney?
No, I sure don't. Sorry.
That's all right. Now, how are you currently employed?
I am currently employed with R.E. Brown.
What is your job title?
I am the safety assistant over to Pat Peters over any accidents and claims.
All right. Do you have a CDL?
No, I don't.
Have you ever had a CDL?
No.
Have you ever actually driven a big rig truck?
I have
Professionally?
professionally.
Why don't you do that?
I don't know.
Okay. You may have gotten behind the wheel once or twice in a parking lot and dabbled a little bit, but you have never really driven one out on the road?
My husband had trucks, so I have just driven them around like in a parking area.
Okay, I understand that, but you don't consider yourself a truck driver?
No, I don't.
You don't consider yourself to have any expertise as far as handling and the driving of the big rigs?
No.
You don't consider yourself to be an expert as far as knowing safe following distances, spacing issues between other vehicles, and the big rig braking issues, acceleration issues, or things like that for the big rigs.
No, sir.
Now, you indicated that you are the safety assistant to Pat Patterson, is that right?
Yes.
And how long have you worked with Pat?
About 4.5 years.
Okay, tell me a little bit about Pat.
Objection form. Can you be a little more specific?
What kind of boss is he?
He's a good boss.
Tell me when you first heard about this incident. When were you first aware of this incident?
I received a phone call from the driver.
When did you receive that phone call? Do you remember the day?
I think it was November the 23rd in 2004.
And what time did you receive that phone call?
I'm not sure. I think somewhere around midday.
Are there documents that would exist that would show approximately what time that phone call came in?
It should be an accident report that we took. We usually write it down.
Let me go ahead and mark.
Would it be easier if we just use yesterday's?
Okay.
Yeah, save us some money too.
All right. Let me go ahead and hand you what we have marked as previously as deposition exhibit number 9 or 10, I believe.
Actually, it is exhibit 11.
Exhibit 11. Okay. And I will represent to you that this was used in the deposition of Pat Peters yesterday.
Okay.
Is that the call sheet that you were talking about or the accident report?
Yes.
Let me also hand you what has been marked as deposition exhibit.
You have a card? Okay.